most important laws in American history, the Voting Rights Act. A divided ruling said a provision meant to stop voting discrimination is unconstitutional. In 1965, poll taxes and literacy tests prevented minorities from voting. That led to protests and marches led by Martin Luther King Jr. and other civil rights leaders. Often protesters clashed with police. Months later, President Johnson invited Dr. King to the signing ceremony of the Voting Rights Act. Now, more than 40 years later, the Supreme Court ruled a provision that requires certain states to get federal approval if they want to change election laws is outdated. In a 5-4 decision, the ruling said the law relies on data that doesn't reflect the current state of racial progress in American society. So joining us now is Kevin Russell, contributor for SCOTUS blog. He is also a partner at Goldstein and Russell. Kevin, thanks for joining us this morning.
My pleasure.
So this is pretty huge. Chief Justice Roberts wrote for the majority, and he basically said, look, this information is outdated, things have changed now, but they're only striking down or throwing out a portion of the law. Does the law still have any teeth?
Well, the court did not strike down Section 2 of the Voting Rights Act, which allows the federal government and private individuals to sue over current violations of voting rights. So that portion of the statute is still intact. What the court struck down was another part, Section 5, which, as you said, requires certain states to bring clear changes, and they no longer have to do that.
So what does this mean moving forward, especially for those states affected by the act?
Well, it means that folks who believe that those states are now changing their laws in a way that are intended to or have the effect of reducing minority voting power or preventing minorities from voting will have to file a lawsuit and go through potentially years of litigation and a lot of costs.
And perhaps, often these lawsuits happen after the election, and who knows if it can really sort of have an effect if they're concerned about any restrictions when it comes to an election. A lot of people are upset about this, partially because of that, because you're talking about years of litigation if you think that something is wrong. What are civil rights groups saying about this?
To be frank, they're apoplectic. They think that the Supreme Court has really destroyed a key part of this really important civil rights law, and they're calling on Congress to fix it.
Not just civil rights groups, but also the president. He said he was deeply disappointed, and the same thing called on Congress to change the law. But what will Congress have to do to change the law to make sure it doesn't end up in the Supreme Court again?
Well, what the Supreme Court has told Congress it must do is adopt a formula that is based on current day data. That is, that identifies the states that today are the most likely to be engaged in voting rights violations, rather than, as the old law did, subject to this requirement states based on what they were doing in the 1970s.
And we also have a few other big cases coming up to talk about. Two of them have to do with same-sex marriage. We have the Proposition 8 case, which is California's ban on same-sex marriage, and the ADOMA Act, which is a law that prohibits legally married same-sex couples from attaining some benefits, some federal benefits. We're expecting to hear from the Supreme Court soon on both of these cases. When do you think we'll hear anything from them?
Well, we are scheduled to get the final opinions for the term this morning at 10 a.m., and since these are two of the three final cases that haven't been decided yet, we're pretty sure we're going to hear about them shortly after 10.
Has there been any discussion about what may be the possible outcomes for both cases?
Well, because there are only a handful of cases left, and Justice Kennedy and the Chief Justice haven't written opinions in the sitting in which these cases were argued, which is a pretty good sign that they may have the opinions in these two cases. So folks think that the Chief Justice may be writing the California case and Justice Kennedy writing the DOMA case.
I want to just double back a little bit and get back to the Voting Rights Act. It was a split court, and we know what the argument was for the majority, but what about the minority? What was the argument there?
Well, the dissent objected to what the court did on a couple grounds. One is they thought that voting rights remains a much bigger problem than the majority seem to think is the case. And second, they thought that the Constitution gives Congress principal authority for deciding what measures are necessary to enforce voting rights, and that the Supreme Court just wasn't giving Congress due deference.
Kevin Russell, contributor for SCOTUS blog, thank you so much for joining us this morning.
Thank you.
Well, the Supreme Court may have decided that